Welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everyone in between. My name is Dan Balkaran, as you can see on the screen, and I'm an employment lawyer at Samfiru Tumarkin LLP, which is Canada's leading employee-side employment law firm. A little bit of housekeeping before we start. If you need to reach us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821 5500. Is it? I don't want to get that one wrong. And unfortunately, I don't have the information in front of me. Let's see if I got it right. See if it pops on the screen. 5900. 821 5900. Okay. Okay. So let's begin. There's a few messages rolling in, so keep those questions coming. And as always, I will be answering all of your questions, employment law, for the next half an hour or so. Okay, this person doesn't have a name, so I'll just address their question. During your live stream today, would you possibly be able to talk a bit about the duty to accommodate for child care? Okay, so generally speaking, so everyone in Canada is going to be subject to some sort of human rights legislation. You're either a federally regulated employee subject to federal human rights legislation or provincial human rights legislation, as would be the case for 90 to 95% of you. And so each one of those, I believe, so each province and the federal jurisdiction have some sort of statutory protection for family status. So the employer can't discriminate against you on the basis of your family status. Now, generally speaking, historically, at least in BC anyway, but I think in most jurisdictions, family status has been heavily circumscribed. So up until very recently, at least in BC, and I don't know about the other jurisdictions, but family status was only, generally speaking, was reserved for childcare situations. I guess it's the state recognizing how important being able to both work and care for your children is to society. And so if the employer made some sort of change, like say you were working day shifts and the employer said you have to work graveyards, for example, and you said no, you couldn't do that because you have to care for your children, and they fired you for not working that shift, the graveyard shift, you would have, among other things, an action in family status, or sort of a human rights complaint for family status because the employer made a change to your schedule which prevented you from meeting your child care obligations. Now, recently, and so it was fairly limited in that regard. And then recently, at least in BC, there was a human rights tribunal decision which seems to say that the move doesn't have to come from the employer. So, for example, so the door is open for this, but it's not clear if that's actually what the law is yet. But if you, say, have a new child, or your child reaches a certain age and requires some sort of childcare where your schedule needs to be changed, theoretically, the employer not accommodating you to the point of undue hardship would be a breach of your family status. I don't see how that could possibly be the law if it doesn't move from the employer, but the door is open for that. So stay tuned, and you're mad, at least in British Columbia. I cannot speak for Ontario or some of the other jurisdictions, but on that narrow point. But if you have something where you think your family status is infringed, and different jurisdictions might call it different things as well. It might not be called family status everywhere. But you're certainly going to want to talk to an employment lawyer if you've got something in the realm of what I talked about. And so you can always reach us if you'd like to speak to us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. Question. I'm not going to identify this person because they've provided their last name. I work at a camp and we have to be bused into the site. We are not paid for time spent on the bus. there any sort of law that says that we should be paid for this? I don't I don't really see that as being very different from, if you lived in a suburb 1 hour outside of of the city, and your job was in the city, and you had to take transit in or drive in every day. So I don't believe so. There may be something in your applicable Provincial Employment Standards Act. A lot of times when it comes to camp employment, there'll be some sort of transport fee or per diem around that, but that's something that is an agreement between you and your employer. So not that I'm aware of. I don't, I don't see that as being materially different than any sort of commute into work, other than, your camp might be remote and you have to be bussed by a company vehicle in there. Although at the same time, if you are on the vehicle and it's owned by the business or by the employer, at that point, are you on the clock? I mean, I actually, it's a very interesting question. I don't have the answer to that question, and off the top of my head, but it is an interesting one. I would say no, but I'm very open to being wrong on that particular question. Raj asks, I was approached by my current company to join them last year in October. Since they approached me to join ASAP, they offered me a signing bonus in lieu of the bonus that I would miss from my previous job. Okay. But they asked me to sign a 2-year contract for this bonus. I'm working as a full-time permanent employee in this company for the last 11 months, but I'm getting the feeling that they will lay me off soon. I was working for previous employer for 5 years as a full-time permanent employee and loved, and they also gave me a better offer to stay, but I decided to move on. Also, when I was hired, I was told verbally it would be a hybrid model, so that would be remote work and on site. And then they changed it for 5 days per week back in the office. Boss bullied and harassed me and other team members. Negative feedback. There's a number of I don't know what this is. This is, I mean, these aren't questions, Raj. Well, I mean, maybe you're getting towards a question, but maybe if you could parse it down to just a short 1 or 2 questions. Job didn't match his current role, or job description didn't match his role. How much severance? Okay, here we go. How much severance am I entitled to, considering that my current employer approached me to join them desperately with promises? Will I also get a bonus amount that I would have gotten February 2024 if I was not laid off? Will harassment from my boss and change from hybrid to full-time in office impact my severance package? Am I entitled to health benefits after I got laid off? This is way too many questions. Will I get more severance because they're laying me off during recession? Sorry, everybody. I'm just trying to sort out what Roger's questions are. Have to pay variable house mortgage. Does that affect it? Okay, so we'll take some of the easier ones out here first. Your external trappings of life have no impact on your severance, generally speaking. So the fact that you have a variable rate mortgage, certainly unfortunate in today's interest rate climate, but no, it has no impact on the amount of your severance you're entitled to. The fact that you are the main breadwinner for your family has no impact on how much severance you're entitled to. The fact that you're getting laid off during a recession, there is some law that talks about tough economic times equals larger severance. I don't know how consistent that will be. I think that really turns on the facts. So if you have a compelling story, or if your matter were to go in front of a court and the court, you were very sympathetic before the court, then certainly, maybe that could be factored in. But I wouldn't bank on first of all, I don't know if it's a recession yet, but second of all, I that's just not something that it does happen from time to time, but it's not consistent. Um, Generally speaking, your benefits end with your termination, so you don't have an entitlement. Well, I shouldn't say that. So in BC, they end with your termination. In Ontario, there's a requirement to pay statutory benefits, benefits pursuant to the Ontario Employment Standards Act. And so there's going to be variation from province to province. So I'm going to defer on that question based on your jurisdiction. The core questions you had, though, were about inducement and bonus. Okay, so why don't we tackle signing bonus? So your signing bonus will be something that, I'm assuming you have an employment contract. If you have a signing bonus, whether or not you receive or are entitled to that bonus is going to depend on what was agreed to. So if you have an employment contract, what does the contract say? Now, in your case, you said you had to work there for 2 years before you got the signing bonus. It's not really a signing bonus. It's more of a tenure bonus where, signing bonuses, you get hired, and as part of the incentive to hire, for you to sign on the dotted line as an employee, they'll pay you $30,000 or something like that, or 10 or whatever it is. That's a signing bonus. Saying that, well, we'll pay you if you're here in 2 years, we'll pay you a certain amount as a bonus. That's really just sort of a incentive to stay bonus, a tenure bonus, we'll call it. So you have to look at the four corners of what your employment contract says. Now, if your employment contract if you don't have an employment contract, then what was agreed to verbally? And so if you were involved in a dispute on that one, it would be what the employer says versus what you say, and you have to get to 50% plus one in terms of the standard of proof. So you have to be believed above the other person that you in fact agreed to the signing bonus. And I think that's a hard place to be, absent contractual documents or absent impartial witnesses that can confirm it. So not your spouse, for example, but somebody else who can confirm that, especially because the employer will probably trot out their own witnesses who say, no, this was never offered to him. So depends what's in your contract, in terms of whether or not, most likely in terms of whether or not you're entitled to that signing bonus. If they terminate your employment, is a very important point. So if you're entitled to common law severance, and certainly the moment you get terminated, you're going to, if you in fact do get terminated, you want to talk to an employment lawyer right away. But if you're entitled to common law severance, or I guess even statutory, you get statutory severance, but during your severance period, your notice period, if you would have hit that 2-year mark that would have kicked in the signing bonus, then you're entitled to that signing bonus unless your employment contract contains clear language that relieves your employer from its obligation to pay that to you. And so depending on the size of that signing bonus, this might be something you really want to investigate. So certainly, Rod, you're going to want to talk to an employment lawyer immediately in the event that you get, as you said, laid off. And just look, there you go on the screen, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. I just want to, before I answer any of the other questions Raj had, specifically inducement, just want to talk about nomenclature for a second. So there's a layoff and termination are used by the public interchangeably, but they're different things. Okay. A layoff is a temporary interruption of your employment where the employer and the employee agree that the employee retains his or her right to his job, but he or she's not going to be paid during the layoff period. Now, if you're provincially regulated, that layoff period will have a statutory end after, where if you hit that amount of time, you're fired automatically by operation of law. And why that's important is because then it triggers from your right to severance, because you cannot get severance without actually being terminated, generally speaking. Okay, so in terms of, I mean, certainly you're not entitled to severance without being terminated without cause, but generally speaking, that's how the layoff regime works with a statutory end if you're provincially regulated. So that's a layoff. It's a temporary interruption of your employment, and the idea is, some employers go through peaks and valleys of cash flow, and if you're in a valley but you want to retain, the employer wants to retain its employees, you lay people off for a period of time. Maybe they go on EI for a little bit, and then you recall them back to work. And this happens quite a bit in the economy. But if it goes on for long enough, that employee can claim that he or she has been terminated by operation of the law. Okay, that's what a layoff is. A termination is you've been fired. Okay, and I know there's a lot of negative connotation around the word fired, but termination and firing, same thing. You've been let go without cause. Okay, with cause is where the employer doesn't pay you any severance. Without cause is that you're entitled to severance. So that's the sort of nomenclature difference. So when Raj here is talking about a layoff, I think he's talking about a termination. Now, his second major question was about inducement. Okay, so he worked for company A. He was in a secure position that he'd been working at for several years, and company B made him an offer. Company B approached Raj, headhunted him, and Raj didn't go looking for it. Company B approached him and said, "We're going to give you all this stuff to come work for us." And so that in law is what's called inducement, and that can add, it's not a set formula, but it can add additional value to the amount of severance you're entitled to if you're entitled to common law severance. It's complicated, but you go from, what does my employment contract say with the new employer if you've been fired? Okay, if it says it doesn't restrict you from common law severance, or if you never signed an employment contract, then you look at, well, did the employer induce me with promises of longevity and money and job advancement and all that stuff to get me to leave a secure job to go work for the new job, and then did the new job terminate me in a short period of time, generally speaking less than 3 years, but the shorter amount of time the better for you. And so there is some argument that the amount of time that you spent at your old job is added to the length of service at your new job to reach a fair severance amount, but it's not really one-to-one like that. It's just sort of a old job and how the facts and how egregious they were of the inducement adds more percentage to your common law severance. So in the event that Raj does get common law severance because he's not limited by his employment contract to the statutory minimums, he really needs to look at this inducement issue. And to get inducement, one, you have to be the company B has to come after you to come work for it. You can't have contacted it. If you contacted it looking for another job, you don't have inducement. So it comes to get you. It makes all these promises to you of that are better than what you had at your former employer. And importantly, in your employment contract, there can't be a probation clause, because a probation clause indicates, generally speaking, I'm not sure the law is 100% on that, but generally speaking, there can't be a probation clause because that indicates that you contemplated maybe this was not a long-term situation. And so if you have all of those elements, then your severance can certainly increase, and whichever lawyer Raj talks to certainly needs to investigate all of that. Inducement is sort of the doctrinal name for increasing your severance when you've been headhunted to your new employer and then you're fired in a short amount of time. But inducement, like I said, it's hard to make out. I shouldn't say it's hard to make out, but it can be difficult to make out on the facts. It's heavily fact specific, but Raj will certainly want to investigate that if he's been when he is terminated. Now, all of that is to say, Raj, you, in the event that you're terminated, 100% want to speak to an employment lawyer. You can always reach us if you want to do that. employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Oh, okay. One more thing, Raj, you mentioned resigning. Do we need to pay back the signing bonus? So, Raj, some of the facts that you're citing are they're in conflict. So you need to talk to an employment lawyer before you do anything. But you mentioned resignation. Do you need to pay back the signing bonus if you resign? Well, it depends. Number one, it depends on the terms of your employment contract. So you might. I maybe not, but they might say, well, we'll give you this bonus if you're here for 2 years, and if they paid it to you already, does the contract contemplate having to return some of that money back? Perhaps. So you want to look at the contract and what it says, and again, you can talk to an employment lawyer, and the lawyer can go through it with you. But I think when you talk about resignation, your right to severance generally flows from your without cause termination. Okay, if you quit, i.e., resign, you get nothing. Okay, now if you're forced to resign, that's different. But you better be right that the employer forced you to resign. And I don't want to get into all of that right now, but you should not quit if you have, well, let me rephrase that. If you're going to quit, if you're going to resign, Raj, you better kick the tires with a lawyer on whether or not you have an entitlement to common law severance, how much that's going to be, and if you have to pay back any of that signing bonus. You need to know what kind of value swing you're looking at before you resign. Just generally with everybody, if severance and getting money from your employer upon termination is something that you think may be applicable to you, you never want to resign. I mean, unless you have to, but you never want to resign without talking to a lawyer first, because resignation is potentially one thing you cannot undo. So definitely talk to a lawyer first, Raj, before you do anything. Okay. All right. I'm not going to say this person's name either. So this is a new question, not Raj. My daughter was let go from her job after an illness. They just stopped scheduling her. She wasn't offered any severance. How long does she have to contact a lawyer and get her severance? Well, generally speaking, from whatever the act is that effectively fired her, she has 2 years to file her action in court, but she probably has 1 year to file you want to check with each of your whatever jurisdiction you're in, but 1 year to file a human rights complaint. And certainly if she lost her job because she had an illness, she's going to want to file a human rights complaint. Now, why wait? If this has actually happened, it sounds like you may be unsure. So there's a difference between she was let go, which requires an active move by the employer, and they just stopped scheduling her, which may not be a termination, right? They may not have any work for her. I assume you're right. They're just hoping she goes away so they don't owe her anything. But you'll want to talk to an employment lawyer and get some guidance on providing an email to the employer to get it to confirm that in fact she has been terminated, or isn't going to. If they say we don't know when she's coming back, and we don't have any, there's no definitive plans to bring her back, or they're just sort of, they won't answer your question. At some point, you can take that as a termination, because it clearly is. But if you were to pursue a severance claim right now, which I'm assuming you have of some sort, if she were to pursue a severance claim right now, the employer could just say, "Oh, no, we were just there weren't a lot of hours, but here we've got some hours. Come on back and work," right? And then you got no claim. Okay, so you're going to want to talk to an employment lawyer for sure. Just one piece before I get into that. If your daughter has been sick for a long period of time, and a year and a half, varies from province to province, but a year and a half or more, and the recent medical opinions do not have any sort of timetable or projection for when she can return to work, then it's possible that her employment has been, it's called frustration of contract, by her illness. And that just simply means that all of the rights and obligations of both your daughter and the employer under the contract of employment are extinguished through no fault of either party. But your daughter could simply not, in that situation, and I don't think that's the case here, but simply could not perform her duties because of her illness, and therefore the employer doesn't owe her anything. So that's something to think about as well, because I don't know exactly what your facts are, but just bear that in mind. Oh, Raj is back. I already got the signing bonus, but I need to pay them back if I resign before 2 years. Well, there you go. That's not something you're going to be able to get out of. So you're going to have to factor that into your evaluation. Is your severance going to offset that? Why do you want to resign? Listen, if you've got a signing bonus and it was $10,000 and there's a new job which is offering you a 60% raise and you could see yourself being there to retirement, well, so what if you have to pay back the signing bonus? Go to the new job, right? It just depends on your personal situation and why you want to leave and the money involved. So, Raj, I think you're probably going to want to talk to an employment lawyer. There's just too much going on in terms of your different questions and the different parameters and consequences of each individual answer with respect to your questions. So, so you can reach us again at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. There's a couple more questions. Let's see if I can get these wrapped up right now. Again, I can't identify this person, but can my employer decide to give me a write-up for something that happened months ago? Well, it depends. Sure, if they're investigating it. I've seen 5-6 months go by while they were supposedly investigating it, and then a written warning occurred. But listen, your employer can give you a write-up for anything. There's no law that precludes an employer from writing you up for something. The question is, in the event of your termination, can the employer rely on that write-up to ground a just cause termination and pay you zero in severance? That's the only question that turns on write-ups. And it depends on the facts of the situation, and if you can demonstrate that that there was no real, transgression here. The employer was simply trying to pave the way to let you go without having to pay you, or something to that effect. So nothing really turns on that, but you don't have the ability to stop your employer from writing you up. I had a case once where the owner of the business would give feedback to all of his employees, but unbeknownst to the employees, he would record that as effectively as a verbal warning. And then if he ever wanted to fire that person, he could go, I gave you 12 verbal warnings this year. But the employees had no idea that this was any sort of warning whatsoever. And so, it can get a little bit messy where you're trying to, because there's a factual record, or at least there's a written record of what occurred, and you've got to demonstrate that each of those things was not in fact a warning, because nobody understood it as such, and it can get a little bit difficult in that regard. But no, there's no mechanism to stop the employer from writing you up. Christina asks, what can you do if your employer wants to put you on a performance improvement plan for reasons that are incorrect? This is basically the same question. Nothing. You can do nothing. If they want to put you on a performance improvement plan, they're going to do that. What you have to do is, if you're saying it's for incorrect reasons, lots of employers and employees disagree about events that transpired that caused, that led to employee discipline. Most employees think they've never done anything wrong. But generally speaking, if you fight till the end on your disagreement with what the employer is saying, probably not going to pass the performance improvement plan, and you're not going to have a job. And so a lot of employees in that situation have to look at what's going on and go, okay, well, what does the employer want to, is the job important to me? Do I have 25 years in the tank and I'm making 25% over and above what I'd make on the job market, and I need to stay here and get to retirement? Well, then you want to tell the employer what it needs to hear, generally speaking. But if not, you've been there for 1 year and you can go get that same job somewhere else tomorrow, then maybe you don't worry about it and you look around for a job, right? But with a performance improvement plan, the employer is putting you on notice that they're trying to get you out of here unless they think this is a drastic situation, and they're either going to get you out of here or you're going to make the changes it wants to see. Sometimes there's nothing you can do, and the employer is just simply papering its own plan to get rid of you. Okay? But if it's not that, and you do have a legitimate shot to save your job here, you may want to think about what the employer wants to hear. If that's and then B, is that something that what it wants to hear and wants you to do? Is that something you can do and are willing to do? And if it is, then do it. But if you don't, you could, of course, no longer have a job very soon. So, but no, you can't stop your employer from providing you with a performance improvement plan. And I think the degree to which, if it's all fictitious and a lie, you may want to put something on the record that explains your side of the story and how you don't think this is accurate, because they're going to fire you anyway. And then that document you put on the record, so to speak, is going to be evidence later on in a dispute between the two of you. But no, generally speaking, no, there's nothing you can do. And if they're giving you the warning shot that is a performance improvement plan, you may want to give a real hard think to, do you want to be there? If so, how do you get the employer to pass you through the performance improvement plan and have you still work there going forward? Jay asks, what compensation should be given if you go more than 5 hours without or before a meal break? So, Employment Standards Act question. It'll be within the act, but it doesn't matter, because I shouldn't say it doesn't matter, but practically speaking, it doesn't, because if they were supposed to pay you a small nominal amount of money, how are you going to enforce it? Are you going to file an employment standards branch complaint against your employer and then have a situation where the employer doesn't like you and wants you out of here for that small transgression? It may be that you can come to some sort of arrangement with the employer if they're willing to do so, where they let you out early one day or something like that. But the specific answer to your question, I don't know. It will be in the Employment Standards Act or regulations, tenant regulations in your province, if you're provincially regulated. Last question. Gene asks, if your employer states you quit but laid you off for normal Christmas break, never called you back but tried to demote you, and then approved your unemployment until it ran out after protected activity. I don't know what your question is. So listen, if your employer, if you didn't quit, the employer has the obligation to prove that you quit, and it's a high bar for the employer. So if you didn't quit, then you may, based on what your employment contract says, you may have a severance claim, and you should contact an employment lawyer right away. And again, remember the distinction between layoff and termination, right? So if they laid you off and there's documentation that talks about a layoff, they can't then say you quit because they laid you off, and you'll win 100 times out of 100 on that disagreement. But if they laid you off and then never called you back, as I said earlier, at some point your employment's going to be you're going to be statutorily terminated, and you have a claim to severance. Okay, so Gene, you should, to find out your specific rights, and 2 years from the date of, I guess, the layoff, to file an action, a claim, because then you'd be statute barred from doing so. But you should talk to an employment lawyer right away. And if you want to reach us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Lots of questions, great questions. Hope I was able to assist everybody. Have a wonderful and safe weekend. You'll see me here in 2 weeks. And that's it. Oh, who are we joining on Monday? Monday with Chris Justice. Monday at 1:30 Eastern Time. Join us for all questions or for his Q&A session on employment law. Other than that, have a wonderful, wonderful weekend.